this morning's docket. That is case number 108830, State of Kansas v. Barlow.
Where would you like us to sit? I'm going first as petition, but I'm technically appellee.
There are some signs. If you could follow the signs, that'd be great.
I gave Miss Isherwood her choice on Tuesday.
I'm sorry?
I gave Miss Isherwood her choice on Tuesday. She was at home over here. Excuse me. May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Michael Barlow. May I please have 3 minutes for rebuttal?
3 minutes is granted.
I think where we are at this point procedurally, there's two major issues we're talking about. First and foremost is the jurisdictional issue, and second is the more substantive issue. First and foremost, the Court of Appeals opinion. I guess in sum, the logic was pretty straightforward. What happened at argument, I think, was in late September, October in this case. Jones came down early November, and the opinion came down in December. Court said, Jones says immunity must be challenged before trial. Had this been raised before trial and it been reached by the district court, it would have been a dismissal of a charge of the complaint. Therefore, it made this jump, skipping a couple steps along the way, that because of that, we can reach this issue under a statutory subsection of 223602 that was not raised in the notice of appeal, thought about by anyone or briefed by anyone, because quite frankly, it's pretty left field. It is an appeal from the dismissal of the complaint. Problem is, reality, this wasn't litigated prior to trial. This was litigated after trial, and this important thing happened called jeopardy attached. And because jeopardy attached, and that's the distinction between cases under 3602B1 and 3602, and the fact that you can't appeal from a motion for judgment or acquittal unless it's a question reserved, is pretty crucial. Now, one of the statements made by the Court of Appeals was that it's not bound by the state's statutory citations. Problem is, and all credit to the state here, Barrett said the exact opposite. And with all due respect to Justice Lukert, I think the rest of the court and Justice Rosen got it right in Barrett. The state, when it makes those sorts of elections, is trying to get a result. When the state makes a statutory election, it's doing it just the same way the state did here when they're trying to get it under a motion to arrest judgment. They want to get the conviction reinstated. Because if it's an appeal under a question reserved, then there is no effect on the defendant in the case. So there's a very big difference why the state wants to pick and elect and choose what subsection it's going under. And Chief Justice Ness recognized this in Barrett, these effects. And I think for all those reasons in Barrett, the state is bound. Allen came out after Barrett. And just to quickly talk about it, it's very different because in that case, the notice of appeal simply stated, we're appealing from this dismissal under KSA 263602. There was no specific subsection elected. And in the case where the state doesn't elect, they weren't held to be bound. So I think that's a fundamentally different case to when the state consciously and specifically makes an election which precludes them and the Court of Appeals, absent some sort of specific amendment, which I believe is the other language in Barrett, and there has been no attempt by the state to amend its notice of appeal. The notice of appeal simply states, notice is given, we appeal the order from Judge Peterson on June 12th in the above captioned case. The appeal is taken pursuant to 223602B2 and 223602B3. On question reserved. And then it states its question. Because the state consciously, specifically, explicitly made its election, there is no way that under our current law that the Court of Appeals had the power to expand the notice of appeal sua sponte under 223601B1. And for that reason alone, for that reason also, the Court of Appeals erred in reinstating the conviction. Moving to the other grounds for appeal started by the state, this was not a judgment of acquittal. This was not a jurisdictional type case. This is a
judgment of acquittal.
I'm sorry, the motion to arrest judgment.
Okay.
Motion to arrest judgment is solely limited to situation. It's not a factual question, which clearly this case involves the district court's interpretation of facts. It was not a situation where the district court ever said it didn't have jurisdiction. The statute, the immunity statute, never makes a statement about jurisdiction. And as a result, contrast this with the Intrastate Detainers Act, which states if such and such doesn't happen, no court shall any longer have jurisdiction. That's not what's said in the Stand Your Ground statute. It simply is not a jurisdictional issue. And frankly, the state argues in its substantive, below the state in the Court of Appeals, the state argues the substantive issue that it could be waived, and it's not, we all know jurisdiction can't be waived, so necessarily, under the state's own argument, this isn't a jurisdictional issue. So we're left with motion for judgment of acquittal and a question reserved. Motion for judgment of acquittal cannot be appealed, and that's frankly what we think this is. The district court reweighed the evidence. Right or wrong, unfortunately for the state, that's what happened, and because of jeopardy, we're bound by those findings. And the alternative, first of all, we don't believe it's a question reserved either, because as we know from the Court of Appeals' opinion, Jones says the question was whether the state cited is, can you raise this after trial? Jones says, no, you can't. The other question regarding the standard was answered in ultraris. It's a probable cause finding under ultraris. Therefore, these are the questions that the state was purporting to reserve. They're not questions of statewide importance because this court has specifically addressed them. As such, it can't be a question reserved, and this appeal should have just been dismissed outright in the Court of Appeals law.
Isn't the state saying that there's something left open by those prior cases, and that is whether the district court can do, and I'm just saying, as the motion for judgment acquittal, even if we accept that, isn't the state still arguing that it can appeal a question reserved on the timing of the district court's decision?
Doesn't Jones, correct me if I'm wrong, but the explicit language in Jones said we find that it has to be raised prior to
when the defendant's raising it. But here we have a sua sponte decision by the district court. I think this is the essence of the supplemental brief filed by the state, is that even if we lose on all these other issues,
I think it's a
we still
distinction.
have a question reserved. They're saying it's distinct because Jones dealt with when a defendant raises it, and this was the district court sua sponte invocation.
If we look at the rationale of Jones, the rationale is we need which I want to talk, that's the second part I want to talk about, is the propriety of ultraris and Jones. But before we even get to that, the reason this court said that it has to be raised further is because the whole purpose of the statute is to avoid prosecution and these burdens that it goes. I don't see how that avoids the burden. It seems that the judge, it's a distinction without a difference. If it's done after the conviction, then you still have this burden under the rationale of Jones. There is no real difference.
When was the first opportunity the state had to dispute the court's finding on the immunity statute? When was the first? I mean, this was just an announcement from the bench, wasn't it? On a motion for judgment of acquittal, which he said he wasn't granting.
He said, I want briefing on it. And then at sentencing, they came together and they argued the issue, and then the court came down with its written order.
He wanted briefing on the judgment of acquittal. Did he want a briefing on whether the immunity statute?
I thought he said, well, I'm not going to decide these motions today. This is at the motions hearing. So I'm not going to decide these motions today. I want you guys to think about stand your ground. And we'll talk about that next. That was my understanding. The state can correct me if I'm chronologically off. But then the district court never said I'm denying the motion for judgment of acquittal. It said I'm not reaching it because I'm reaching stand your ground, so I don't need to reach it.
There's no need to consider it. He didn't
Correct.
consider it.
Correct. So it's technically never been reached. But the bottom line, it doesn't matter as a finding on the facts, and we're left, as I said, we're left with the judgment of acquittal. It doesn't matter when the state's chance to challenge it is then, because the state can't appeal it. Were you asking when the state can appeal it, or when the state had a chance at the district court?
I didn't. I wanted to understand when the stand your ground theory came into play, who brought it into play, and if anybody had an opportunity to brief it or discuss it or to challenge it prior to that decision being made.
It was my understanding the district court brought it up at this motion hearing, saying, "I'm thinking about this."
Okay.
At that hearing, he didn't make the decision at the motion.
Right. Okay.
That happened later. So the state had its opportunity down below to deal with this.
Does that make any difference if the judge effectively acquits the defendant without giving the state its due process rights or whatever, which it doesn't have, but give the state the opportunity to argue against it? Isn't that still an acquittal, and the state's left with a question reserved, so it doesn't happen again? In other words, even if the acquittal was affected without giving the state an opportunity to argue the legal issues involved, that's still an acquittal, isn't it?
Correct. I think I follow you there. I thought there was a couple questions, but I think so. You're ultimately getting at what does it matter as far as the state having the chance to argue on the stand?
Even if it's a wrongfully or inappropriately entered acquittal, an acquittal is an acquittal.
Correct. That's double jeopardy makes that clear, and that's why we're stuck with it to the state's detriment. Quickly touching on the substantive aspect of it, the whole rationale behind Ultreras is that we have this new right created because the state now has, if it's raised, the state has to bring up, has the burden of showing probable cause that there was not justified use of force. And the problem is everyone's ignored this 1983 Jones case that says, which is long, 23 years before Stand Your Ground came into existence. And the court said there, the defense has the right to raise defenses at the preliminary hearing. That includes justified use of force defenses. And I think the court recognized that you're still stuck with that rough standard. But the reality is in Kansas, you could, unlike Kentucky, which my research in Kentucky has no indication that you can raise a defense like this in Kentucky, which is what the court relied on. The court relied on the Kentucky Supreme Court's rationale in Ultreras. But the reality is there is no benefit under this. The defense always had the right to raise self-defense at a preliminary hearing. And as the state said in its brief, well, you may never win it. And the reality is in an ethical world, you should never even have charges brought if that's the case, because the state should have never brought charges. Because the only way you win in preliminary hearing is if there is absolutely no evidence contradicting self-defense.
Jones is solely about a defendant's right to present evidence, isn't it?
Yeah, well.
Isn't that really the context for the 1983 Jones case?
No, I think
it's about what the defense can do as opposed to what the burden of the state is.
it's still the same. It cites the burden of probable cause, and it says that even though this is the burden, it's all taken in the totality of the circumstances, which is exactly what the probable cause burden is. The judge takes in totality of the circumstances and a light most favorable to the state. And there has to be something different, and that's why we contend that it should have been more appropriately this Florida type situation. This court needs to revisit Ultreras because the foundation just doesn't stand when the reality is you had the right to do this before. There is no new benefit that way. And with respect to Jones, the one thing that this is different from Jones is because this is a situation where, as a matter of law, rape is great bodily harm. The jury did not have that in a jury instruction, for better or for worse. They didn't have that before them. Contrast that to Jones when we're talking about a strict, straight-up battery case, where it is a question of fact whether or not great bodily harm actually occurred. In this case, we don't know if the jury knew that as a matter of law, rape occurred. And couple that with the fact that the victim of the force that Mr. Barlow was defending from could not be served at the preliminary hearing, wasn't even interviewed by law enforcement until a month before trial. She was largely unavailable to everyone. There was no way really to find out the real evidence in this case that supported all the blood that was in front of her that indicated that it most likely was an assault. And I'll just point the court to that. The district court really did an excellent job of noting what the real problems were factually in this case. But none of that stuff could have been found out until trial actually happened. And so this isn't a situation like Jones. There are reasons why the actual standard that happened just because a jury convicted may not preclude standard ground immunity if that information doesn't come to light till this point. And it seems that the statute, the plain language of the statute says it proceeds through arrest and prosecution. And this court has said prosecution goes all the way through sentencing. Jones is a little different. And I think the Jones court, you can easily distinguish Jones and say Jones was raised for the first time on appeal, which is a very different thing. You don't get new evidence on appeal. This is something that happened before the trier of fact. The district court was there. The district court saw the witnesses. This is something that I think fundamentally distinguishes Jones on those points. So I think this court should, first of all, I think the easy way out for this court is to go with my jurisdictional arguments and say this appeal just should have been dismissed to begin with and go ahead and dismiss the appeal. But if the court does not dismiss the appeal, or the court also cares to comment on the issues, I think Ultreras needs to be reconsidered in light of Jones. 1983 Jones, that is, not 2013 Jones. And that 2013 Jones should be distinguished from this case and hold the holding limited in 2013 Jones.
Any questions of counsel? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. The district court in this case did not enter a judgment of acquittal. It didn't use the right standard to enter a judgment of acquittal. It didn't consider all the evidence to enter a judgment of acquittal. It ignored the fact that Mr. Barlow had no right to self-defense immunity once he chased Mr. Martinez out of the apartment into his own apartment.
Did the written order resolve factual elements of the offense?
It did talk about factual elements, but it didn't do it the way you should in an arrestive judgment.
Well,
It didn't
but
talk about sufficiency of the evidence.
It didn't talk about sufficiency of the
But
evidence.
it said there was a preponderance in favor of the self-defense, basically, of the immunity.
Yes.
Doesn't that necessarily imply there's a reasonable doubt?
Except for it didn't talk about...
I know
understand.
it didn't. It in fact denies that it's addressing a motion
Correct.
for acquittal at all and pins it to the immunity statute. But I'm just looking at the substance. Regardless of the label, the substance he talks about. Hold on just a second, I'll get a copy of it. He talks about the victim perjuring himself.
Right.
He says that the defendant appeared to be credible. I mean, there's repeated, these facts lend credibility to the defendant's testimony. Interview lacks credibility. all of this, after listing out several items of evidence, all of this consistent with defendant's version. Lists more evidence about the blood, consistent with defendant's version. Apparently looks at the bullets himself and knows about bullets. Talks about the clicking sounds that every revolver, or like most revolvers, 3 clicks. I mean, just kind of very fact intensive, and essentially decides what those facts show. So isn't the substance of it a ruling on a motion for judgment of acquittal, even though he says it's an immunity ruling?
No. I mean,
Just because of the label?
because of the label, because he's not actually getting to whether or not the state had sufficient evidence. Well, he's also basically stopped at the wrong part. He stops at what happens in in Barlow's apartment rather than what happened in front of Martinez's apartment. He ignores the fact that there is no stand your ground immunity there. There is no self-defense at play, and overlooks lots of evidence. I understand that there were factual findings made, but he did so what seems to be under the erroneous interpretation that Mr. Barlow is now asserting that you can raise stand your ground immunity at any time. And if that's true, then it's basically jurisdictional, maybe like personal jurisdiction that you can waive. If it's jurisdictional, it more fits within an arrest of judgment, which is what the state believes the district court actually did here.
So your position now, I had a little trouble tracking the
Right.
state's position on whether it was jurisdictional or not through the course of the briefs, because it sounded like initially you were saying it can be waived, it was waived, and then
I
a
don't-
motion for arrest of judgment focuses on either an inadequate complaint, which is not a claim that you've made,
Correct.
or a jurisdictional flaw, which I read to be a subject matter jurisdictional flaw. You think it's personal jurisdiction?
I think generally it's substantive.
It usually is subject matter jurisdiction, something that really just voids the prosecution.
I'm
And-
not saying that self-defense immunity is jurisdictional. I
Yeah.
think this court completely got it right in Jones. It needs to be raised
So
pre-trial.
how is this any more ruling on a motion for arrest of judgment than it is a motion for judgment of acquittal?
Because
he doesn't call it that either.
Because where the district court did it, he apparently thought immunity was jurisdictional, it could be raised any time. Why else would he raise it post-conviction? Basically, what the judgment did in this case was create I'm not going to arrest the judgment, there's some other way I can reverse this conviction. And the state needs to figure out whether or not that's true, which is either directly on the merits or on a question of reserve, and whether or not the state has any ability to appeal when the district court does something that has, under Jones, no authority to do whatsoever. Well, open to whether Jones is going to say you can sua sponte, apparently, even though the defendant can't raise it, whether or not the court can sua sponte raise it.
Let me ask that question. If it is true that stand your ground immunity is immunity from prosecution, why shouldn't stand your ground immunity be permitted to be asserted through the entire proceeding at the district court, up through sentencing? That's defense counsel's argument.
Correct. Because of subsection C, which specifically says the prosecution can commence and presumably continue as long as there's probable cause. The standard isn't once you've been found guilty beyond a reasonable doubt, at that point you've lost any, well, first of all, generally qualified immunity is immunity from trial, it's not from the entire prosecution. This is a odd mix of immunity in the first
So
place.
what would, just hypothetically, what would be your rationale then if the immunity had been raised, say, during trial, during the development of new facts, or maybe at the close of the state's case in chief? Why couldn't it be raised at that point? I mean, the defendant arguably at least still has the ability to obtain immunity from the rest of the prosecution.
This is where my only disagreement with Latour is it seems like once the probable cause determination is made by the court, this shouldn't be raised anymore.
But it hasn't been raised. I mean, excuse me, it hasn't been determined.
Correct. That's true. It was not determined yet.
And so again, I'm just kind of struggling with Jones says can't be raised for the first time on appeal, and defense counsel argues that should be the limit of that holding. However, there is language in the syllabus about it needs to be raised before trial. But that does kind of leave open this gap of time between when the trial starts and when the trial ends, essentially. And my question is just, what's your best argument for why Jones ought to extend to eliminate the ability of the defendant or the judge sua sponte from raising stand your ground immunity during that in-between time.
So before conviction?
Right.
Okay. Once the trial starts, it's kind of already in front of the jury. It might as well just go through and
It's
let the
immunity,
jury decide.
though.
That's true.
It's immunity. It's not a fact question for the jury.
Because immunity can be waived by not being raised in a timely manner. I mean, that's basically what the 1983 holds and the reason it's supposed to be raised prior to trial. And the same would be true here. It's waived because it wasn't raised.
And that's just a judicially made rule. It's not in the
That is-
statute, right?
Yes. And then, but if this court disagrees and decides it is a judgment of acquittal, we would ask for basically to know that very question. When can the court raise this? How far can it go? And can the state appeal from something that appears to be an arrest of judgment because the court seems to think it has jurisdictional grounds to raise this on its own at any time it wants to do so?
Do you-
But that's not the basis of your appeal, is it? Oh, yeah, you said arrest of judgment or question reserved, didn't
Yes.
you? A question reserved, I wanted to ask about that anyway. What does it say? I
And the
think it's
notice of
pretty.
appeal?
Yeah, I mean, I can say what it says, I can read it. But is it a procedural question or a substantive question or both?
I personally would never ever put the question reserved in a notice of appeal, so, but since we did it,
Since you did, I think you're stuck with it.
yes, correct. And I don't remember, I know
I can read it to you if you'd
that would be,
like. It just says, as to whether the court correctly interpreted and applied 215231 post-prosecution to override a jury verdict that rejected the provided defense of another jury instruction and defense of another claim.
yeah.
I don't know, I think it's hard to understand. And you restate it in one or two of your briefs.
Yes, I did, in my first one in the Court of Appeals, I attempted to restate it so it would be
I think at
easier
one
to
point you said it
understand.
was 2 questions.
I did break it down into 2 questions,
Mm-hmm.
and now I'm kind of rephrasing it yet again.
Okay, yeah, that's what I'd like to know what you're talking about.
Yeah, I mean, the broadness of the question was basically how does self-defense immunity work? Is this something that fits within the statute? That was what the attempt of the question was, and then we keep rephrasing it to try and make it fit the facts as the law changes, will fit the law. And to try and, we're still asking the same thing.
Say it one more time for me.
I'm sorry.
Just say what is the question reserved?
How does the substantive, or how does self-defense immunity work?
Oh, okay.
Yeah. Did the court substantially and procedurally, or substantively and procedurally apply it the right way in this case? I mean, we think the answer is no. But we want to know, can the district court do this? Can they sua sponte raise jurisdiction? Can they do so after conviction? Or even up and, well, we would love the answer through up and through trial too. We would, anything that would define the limits of how substantive or self-defense immunity works we need, because if, as you can probably tell from Otreras and Jones, we're struggling. We don't exactly understand the limits of the statute. We don't know when it's supposed to be raised. Any answer you're willing to give us would be very beneficial, and I'm not sure if you...
the question of statewide interest.
What?
And that's the question of
Yeah,
statewide interest.
Yes, statewide interest is, I mean, this court has heard numerous self-defense cases. If self-defense immunity can be linked in most of those cases, this is going to be an ongoing issue for many years to come. Exactly how this immunity applies when the statute is not entirely clear.
Isn't that something the legislature can fix?
They could provide guidance, yes.
I mean, it seems like all they have to do is just say, it needs to be raised at preliminary hearing or wherever they want it raised, and then we're done.
And that could be ideal, but this court can also say the same thing based on interpretation. You can at least clarify whether or not it is jurisdictional versus non-jurisdictional. I think Jones says, New Jones, 2013 Jones, says that it's not jurisdictional because it's banned from being raised on appeal. But whether or not the district court can sua sponte raise it is within this court's realm.
Do you agree with Mr. Dunn that there was an invitation to address Stand Your Ground prior to the announcement by the court?
I don't remember that at all.
I tried to find that somewhere, and maybe there was.
The court order
Just wondering how much of a surprise this was.
I think it was a surprise. I mean, I know the state didn't file any briefs on Stand Your Ground. We didn't get the emergency phone call about, this might be applied. And the court just said on its own motion it considers it, but I don't
Okay.
know if in the hearing he mentioned that he was considering that. I know there is an indication that he told the parties that he was doing the judgment of acquittal, but I'm not sure about the Stand Your Ground. And
Any
if this,
further presentation?
just briefly, I'm not sure if this court, I mean, the question here is jurisdiction, and I know I filed a brief on whether or not this court has jurisdiction over whether or not it's a arrest of judgment. I think no one's pressed me on that yet, so I'm hoping you found that you do have jurisdiction. But the only thing the Court of Appeals did in this case was say it's an appeal from a dismissal, which is what it would have been if it had been done right. If the court had done it before jeopardy attached, which is why we want it to be, that's another reason we want it to be before trial, is we want to be able to appeal if they do indeed dismiss on self-defense immunity. So whether or not that's a viable rationale, it's the only way the state has any kind of ability to protect itself from a district court going rogue like it kind of did in this case. But if there is a jurisdictional issue on whether or not you want to address the alternative grounds, like the question reserved and the arrest of judgment, you could also just remand to the Court of Appeals for those issues, because the only thing the Court of Appeals reached was the motion for dismiss. I can't sum up what I want because it's complicated, but ideally we'd like our conviction reinstated. If not, we'd like the question reserved answered.
Any more questions of counsel?
The revised, new, and improved question reserve.
Yes.
Okay.
Thank you.
Thank you, counsel. You reserve 3 minutes for rebuttal.
I don't think I can do anything but muddy the waters further, so I was going to ask if there were any questions the court had following the state's presentation that the court would like me to address.
Did you find anything while you were sitting there that would be responsive to Justice Rosen's question?
I was rapidly looking. The order says on the court's own motion,
Right.
I know I recall it.
You think there might
I
have been
can't
a reference
remember
in
when.
sentence- at what point did you say a post-trial motions hearing and then
It
they
was
came back?
my understanding, and I don't know if I got that. There was one last place I was trying to look, and I ran out of time, which would have been in the actual ROA. On June 12th, I think it was on June 12th. And I'm not sure exactly. I know I'm getting the sentencing was continued on June 12th. And I had in my notes for my argument notes, I had a timeline. I'm sorry, I'm getting too far afield here. I had my timeline written that the motions hearing, trial April 23rd, motions hearing May 2nd. And I'm not sure if that's right, where I got that from. But it also looks like on the sentencing hearing it was continued June 13th. And I just can't find it in front of me. And I'm sure I don't want to sit here and just spend my time looking for the court. So the court's going to find what the court's going to find. But it was my recollection that yes, there was actually
Some
was
kind of
no.
heads up, you think? Okay.
This wasn't something that just came completely out of left
Yeah,
field.
you understand my concern is that
The state should have had an
Opportunity,
opportunity to try and argue against it at that point.
and at least bring up, the trial court was fairly thorough in its factual recitation about why he believed, the trial court judge believed that there was credibility issues and believable issues, but then there were also other facts, shots filed after the attack outside the apartment at the grandmother's residence, just to argue that for the court to consider. And I just want to be sure that the state was afforded an opportunity to present that.
Well, I think they could have, regardless. First of all, I believe they were. I think they didn't file. It doesn't look like anyone filed anything.
Right, okay, that's...
But even if they they still had the sentencing hearing to try and talk about this again, or at some other time. The state just made no effort to. The state just
Not if it
acquiesced to this.
Not if it went away.
No, how
There
would
was
the
no
sentencing
sentencing.
hearing, yeah.
There was no sentencing in this case because
Well, there was a sentencing
for the
because there were two
for the
other charges.
charge.
There was an
Well, there's only
aggravated
one
assault and
charge.
criminal.
He only
I
got
thought-
convicted on one other charge.
Oh, he was acquitted of the criminal. That's right. He ended up doing this individual has already done his. The district court sentenced him to the maximum sentence, but then granted a dispositional departure, and he did 3 years probation, which, to my knowledge, he's completed at this point in time. But
I don't think there's an opportunity after this to argue it, but maybe, I mean, he acquitted.
Motion for rehearing or motion to revisit this. right?
but I
And there was no effort for the state to wave its arms and say, wait a minute, judge, this is procedurally wrong, you can't do this to us.
Not till a notice of appeal. And that's even, I was at a loss on this because we didn't get into this until this was docketed way out of time, and we didn't know exactly. We technically never got served with the docketing statement, but the state had a lot of opportunity to do something and didn't do anything for a long time. And if anything, I think they waived any time at that if they did really want it at that point in time. But we believe that they had a chance below. It's questionable whether or not they technically, the state has due process rights in the same fashion as a defendant.
No, I understand that, but I,
And I understand it's just, we're talking just
Right.
flat out just being fair, but I don't think that that's a right necessarily that the state has.
yeah, I agree.
So,
Any further questions?
we would ask that Court of Appeals be reversed and charges remain as they are. District Court was correct and affirmed below.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time,